go through the roll call. Do the roll call of the benchers and paralegals who are on the phone. Robert Bird, Michelle Hay.
I'm here.
George Hunter.
Here.
Ronald Maines.
Here.
Ross Murray. Mr. Strasberg.
Here.
Mr. Yaketti.
Here.
Mr. Rabinovich.
Here.
Anyone else on the phone whose name I have not called?
Yes, it's Julian Porter.
Thank you, Mr. Porter. Anyone else? All right. Could everybody who's on the phone please *6 so that you're muted until you want to speak, and then you can speak. Thank you. Mr. Wadden. I should say, Mr. Wadden, before you start, that I still have a very long speakers list, and my intention is to call the vote around 12:30. So would you please keep that in mind when you're making your remarks? That we have a lot of people who want to have something to say on the motion. So if you wouldn't mind trying to be as succinct as possible. Thank you, Mr. Wadden.
Now you tell us. Mr. Treasurer,
all about time, but the time value of money. Okay, thank you, Mr. Wadden. Please go ahead.
Mr. Treasurer, I'm going to be succinct, and I'm not going to repeat anything that's been said by others. I want to say that my view is that I support the position of the majority in principle. I agree with practical training. I agree with articling. I agree that articling remains, in my view, the best means of meeting our professional standards. And that has been well voiced by other speakers, and I won't repeat that. I also agree with the position of the majority that fairness dictates an alternate means of qualification be made available in the circumstances that are so well set out in the report. I agree that there is time has come for consideration of another route. I note that there already is, of course, another route available to qualification of the profession. You can clerk in the court, and that's regarded as a means, an alternate means to articling. Frankly, I think it's overly pessimistic to say that the course that's being proposed would automatically be second tier, or that those who take it would be stigmatized. Those who clerk for the courts don't article, but I don't think anyone would regard them as being stigmatized in the profession. The issue I have, though, and the concern I have, is that the motion as it's worded requires and asks us to support all of the details of the report. And all of the details include something that gives me great concern, which is that of the costing model that's in the report. I'm very concerned about the model in the report that effectively imposes, fee-wise, a 100% increase in fees imposed on all students, including those who are actually working in an articling position. Frankly, I see this as imposing a tax on students, an unfair tax that is going to be imposed on a generation of future students. And these are not students in the far future, these are students who are currently in second year and first year of our law schools. Many of these students are students who perhaps have lined up articling positions or will seek articling positions. Yet, the burden of the cost, a full doubling of their fees, will be imposed on them. And I have a concern as well about the fact that it's clear from the report that the future costs, both of the course that's being designed and of the inherent costs in addition to licensing, are unknown. And the number of students who are going to be taking the proposed course are unknown. The costing model may create incentives to actually take the course that we don't foresee right now. So there may be more students taking the course than are anticipated. The cost for the course may be higher. In effect, what I fear is that we're asking the future students to effectively write a blank check. We're effectively asking them, we're effectively imposing on them the cost of the course the cost of the whole program, but it being an entirely unknown cost. The estimate is already double what they're already paying. It's already a 100% increase, and I'm gravely concerned that that cost is going to increase in the future. I recognize that Mr. Faulkner's motion is on the table. I see, frankly, that there are alternatives to costing available, one of which is set out in Mr. Faulkner's motion, which is that the profession adopt the cost of the changes. Another alternative, which is referred to in the report but not accepted, is that those who actually take the course pay the tuition for the course. I recognize I might be in a minority of one in feeling that that's a view that's both practical and principled. But even going to what Mr. Faulkner has proposed, my concern is procedurally that that's an entirely separate motion. It's not at all incorporated into the motion that's before us right now. It's not incorporated into what we are being asked to vote on. And I'm concerned that it's only going to be considered procedurally after we've already voted on a motion that imposes this cost model on the future students that I've expressed my concerns about. So, unless I were confident that the costing model were changed, that there wouldn't be this burden imposed upon the students, I would find that I'm very reluctant to support the motion as it now stands. Thank you, Mr. Treasurer.
Mr. Evans?
Thank you, Treasurer and colleagues. I am speaking on behalf of the motion. The President of the Ontario Bar Association, Morris Chocolate, contacted me to advise me that the Bar Association is supporting the motion of the majority report. And during the past few weeks, I've had a number of communications from several dozen lawyers, almost unanimously in support of retention of articling, and that is my view. I do agree with all members of the task force that the status quo is not an option, in that if we do not provide an avenue for a large number of our law school graduates to qualify to practice law, that is not acceptable. And if we defeat the motion, in my view, we will be stuck with the status quo, which I believe is not acceptable, and I think that's generally agreed. As a venture and as the director of Law Pro, I urge that we adopt a solid mentoring program as part of our reform so that our new lawyers, whether they article or not, will have the solid support from readily accessible mentors to enable them to develop their confidence as lawyers and to promote their compliance with the rules of our profession.
Thank you, Mr. Evans. Mr. McKenzie.
Mr. Treasurer, members of the bench, to belabor the obvious, it will become apparent, particularly after the debate that we've heard so far this morning, that these are exceedingly difficult issues on which reasonable people can differ. And I certainly wouldn't want anything that I have said or am about to say to be interpreted in any way as diminishing the respect that I have for the work that has been done by the task force, both by the majority members of the task force and by the minority members of the task force. They've addressed difficult issues in creative ways. Having said that, I strenuously urge members of Convocation to defeat the recommendation that the majority report be adopted. And as by way of an approach to considering the issue, I'd ask the members of Convocation to consider it from the vantage point first of the students who are affected, who've been unable to obtain articling positions and will be unable to obtain articling positions in the future. Secondly, from the vantage point of the profession, and thirdly, from the vantage point of the public that we serve, which of course is most important in my view. From the vantage point of the students, many of them reject the approach of the majority of the task force. They've been in formal education for 20 years or more in some cases. The last thing they want, and I say the last thing they need, is another 4 months or 2 months or 3 months on minority view of further classroom education, even combined with a co-op program, the details of which and the efficacy of which we must have some doubt about at this stage. What they need are real jobs, working under the supervision of real lawyers, serving real clients and dealing with real issues in practice. And although I say this with some hesitancy, I'd add that many of the students who need articling the most are those who are unable to obtain articling positions. So many of the students who we're trying to accommodate through the majority's proposal and the minority's proposal are simply saying to us, give us a break. That's not what we want. Spare us. Turning to the vantage point of the profession, I will say only that it's apparent to anybody who reads the submissions received by the task force, which are collected, and those who read the submissions that we've reached since then, that the community of lawyers in this province is, as it always has been, very, very supportive of the effectiveness of articling as a pre-call training program, experiential learning program. And while I agree with your admonition, Treasurer, that we owe no allegiance, certainly in any formal sense, to our constituencies, nevertheless, I say that we shouldn't be dismissive of the views of the profession either. There is wisdom in crowds, and the views of the profession are entitled to great weight in our deliberations. And finally, and most importantly, I ask you to look at this from the point of view of the profession. And the major point I want to make here is that we cannot be sure, if we embark on this route, that we will be assuring that new lawyers called to the bar will be competent to practice. I've been fortunate to have practiced in very fine law firms over the course of my career. And though we've been in a position to attract and have attracted outstanding students, I certainly can tell you that when they've landed on our doorsteps, they haven't been competent to practice law. And I don't agree with the view expressed by some that if you article in a large or medium-sized firm, that prepares you only to practice in a large or medium-sized firm. I've always taken great comfort in knowing that the students who've worked with our firms, whether they return there or not, have had the benefit of that experience of dealing with lawyers, the professionalism, the values that they bring to the table, the competencies that they learn during that process. And even though they undoubtedly have more to learn, if they set up sole practice particularly, they're much better positioned to do so. I found persuasive the views expressed by law associations and practice associations that we are much better served if we have untrained students who are supervised than we are if we have untrained or inadequately trained first-year lawyers who aren't. A very serious concern has been expressed about the prospect of lawyers who are inadequately trained starting to practice when they're forced to start as sole practitioners. And yes, we can institute post-call mentoring programs, but it's very, very difficult to either find the resources and to effectively supervise a first-year lawyer who isn't practicing with his or her supervisor on a day-to-day basis. But the concern that troubled me the most along these lines, the competency and our inability to ensure entry-level competency, ensure the public that we have entry-level competency, was the comment of the 4 chief executive officers of other law societies across Canada. The letter came from the chief executive officers in Alberta, Saskatchewan, Manitoba, and Nova Scotia. And they reminded us that we're autonomous, of course, at the Law Society of Upper Canada. We're jointly attempting to raise national standards across the country. And they raised the question, or they said to us in that submission, if Ontario abandons articling as a requirement for call, that will raise the question in your colleagues' minds across Canada whether lawyers called, all lawyers called in Ontario are competent for the purposes of the National Mobility Agreement. And I say that's a very serious concern. What does that say about the credibility of the Law Society of Upper Canada? And what does that say about the reputation of the legal profession in Ontario? And that is a compelling argument and something that I'm concerned hasn't received more consideration as part of this debate and part of this process. So for those reasons, it's my respectful submission that we should defeat this recommendation today. Now that isn't to say, I hasten to add, that we should do nothing. And it isn't even to say that we shouldn't consider refinements to what the majority has recommended, as well as the minority view and the view put forward by others. The alternative that I find most attractive is concentrating all our energies into increasing the number and the quality of articling positions across the province. Now, it is said to me, we've tried that. That's true in a sense. Since 2008, we've attempted to come up with more articling positions, and those efforts have not failed. We've succeeded in creating more articling positions. The reason that there's a gap now is that it's a supply-side problem. We're getting far more applicants from outside the jurisdiction particularly, but also from within Ontario and from other provinces. That's the reason for the gap. It's not that we haven't been able to create articling positions, but more importantly, there are ideas that we haven't pursued in our efforts to increase the number of articling positions. And I've learned of a number since I've been putting forward some thoughts that I have on the issue. We haven't looked seriously at the idea of providing fee reductions to articling students who accept positions in underserviced areas, or considering fee reductions for the lawyers in underserviced areas who hire them. We haven't considered Mr. Wright's constructive proposal that we change the articling terms so that sole practitioners, particularly outside of Toronto, can employ articling students continuously without there being a gap. We haven't considered sufficiently Mr. Ruby's constructive suggestion that in combination with Legal Aid Ontario, we create more opportunities in the criminal law bar. Presumably that solution, if it is a solution, could apply equally in the family law bar. Mr. Epstein was just discussing a proposal with me over coffee that he has. We haven't considered the idea of, if necessary, reducing articling terms to 6 months. I don't favor that particularly, but it would double the number of articling positions at least that we have available. So there are many, many things that we can do, and yes, they need more study. But what we should do, in my submission, is reject the majority proposal today, get on with that job. And I'd only add that there are other interests served by our creating more articling positions in those underserviced practice areas and those underserviced parts of the province. It's in the student's interest, the profession's interest, and the public interest that we have criminal lawyers hiring articling students again. It's in the student's interest, the profession's interest, and the public interest that we have family lawyers hiring articling students again. And it's certainly decidedly in the student's interest, the profession's interest, and the public interest that we have sole practitioners, small firm lawyers in county towns, in underserviced areas, hiring articling students who will become practitioners and address the aging bar problem, and in part our access to justice challenges as well. Thank you for your attention.
Thank you, Mr. McKenzie. Mr. Gottlieb?
Thank you, Treasurer. Treasurer, I particularly appreciate the opportunity to address Convocation today because I'm only a life venture. I cannot vote. But I've been a sole practitioner for the last 42 years. I've practiced the last 30 of them without a secretary, so I think my perspective is likely a lot different than many of those in this room. The precipitating factor for the task force's report was the inability to provide articling position for all the candidates for admission to the profession. The precipitating factor was not really the improvement of the present system. With all due respect, I think if the raison d'etre for the task force had been the improvement of the present system, the recommendations that are before us today would not be here, and they would be vastly different. All I know is that I don't want a barber to give me a haircut without practical experience, without practical training. I know I don't want a plumber to install pipes in my home without practical training. I know I don't want a dentist to perform dental work and give me a root canal without any practical experience, and I don't want a surgeon to operate. I can go on and on. I also know that there are increasing errors and omissions claims against practicing lawyers, and I regret very much that most of those claims are against sole practitioners. And the same thing applies to discipline matters that are before us. Most of discipline cases involve sole practitioners. I also know that most of the additional lawyers who will be qualified under a watered-down admission system will end up in sole private practice. They will not have sufficient practical training, talking about the additional ones. I think that law practice program, the ones that have articled, but the additional lawyers that will be in practice that do not have sufficient practical training will compound the problems that we have now, and many of them are going to compete on the basis of our realistically low fees and taking shortcuts. That will compound the problems even further. The majority recommendation of the articling task force and the minority recommendation will increase the number of new lawyers, but they will not ensure quality professional services. It will ensure more lawyers in practice. It will ensure more access to legal services. But it will not ensure more access to quality legal services for the ordinary public.
Thank you, Mr.
Thank
Crosby.
you, Treasurer.
Ms. Doyle? Excuse me, I'm sorry.
Ms. Boyd.
Ms. Boyd, I'm sorry.
Well, thank you, Treasurer, and I want to express my delight that the profession has been so interested in this discussion as well. But I'm here as a public member, and I think the discussion is equally important to the public, and the public does not appear to be as engaged in this topic as I might wish. So I'm hopeful that as we make our decision today, we're going to be keeping in mind our obligation to make a decision with respect to the interests of the public. I think the public would be delighted if they were part of this discussion, to hear the comments of people like Mr. Brett and others who have talked about the need to ensure competency. for anyone who is going to be loosed on the public to practice law. I think the public relies on the Law Society to ensure that no one is licensed who isn't competent to practice law. And I think the public would be concerned to hear how many of us have reservations about how the current system is actually preparing people to do that. One of the things about the majority report is that it acknowledges a real need to improve our sense of confidence in the practical side of training under Article. That is clearly part of the recommendation, that we need to be sure that there is a threshold of competence that is met both by Article students and by those who might go through an LPP. For those of you who are experienced with equity talk, thresholds are very important. Because one of the things, the only way we can have integrity in this organization around self-regulation is to make sure that everyone who is licensed at least meets the same threshold. In equity talk, thresholds are very important. I'm in a situation right now where I'm getting first-hand experience about how people think they have accessible physical facilities, have often invested a lot of money in bathrooms and wider aisles and all the rest of it, and forget about that step at the threshold that means I can't get the wheelchair to the level where equity exists. And I think when we talk about this issue, one of the concerns that the Fairness Commission has, that the public has, is, are we regulators or are we gatekeepers? If we're gatekeepers, we don't meet the smell test, quite frankly. And I do want you to know that I don't think that's the intention of anyone here. But when you are part of a system, it's hard to recognize the systemic discrimination that you may be part of. When people in this room talk to me about how important it is where somebody articles, I don't know anybody in the public who asks that question. They don't choose their lawyer because of where they articled. In fact, they don't even know enough to ask that question. Where you articled, frankly, and I'm sorry to be so blunt, is a nudge, nudge, wink, wink. It tells you that someone has been admitted to a golden circle, that they're part of the network, that they're connected. It means something in the profession, and it's not necessarily bad. Because a lot of the profession really depends on knowing what the routes are in which you can get the advice that you need, get the mentoring you need, recognize the techniques that have worked for others in the profession. But if it is a gatekeeping exercise, then we will not meet the public test of fairness. And someone will take an action to say to us as self-regulators, you're not meeting that smell test. I don't think that it is in the interest of anyone, including the profession, to do away with Article. I absolutely disagree with the abolishment of articles wholesale, although I think they can be improved. And I'm not very impressed with the argument that we tried to do that and the big firms said they wouldn't take any articling students. I think we have to really look at what's going on when we hear that kind of comment. We have to provide another route, or else we are going to lose the privilege of self-governance in this profession. Because what matters and means so much to the hearts of those who have been through the system, and as Mr. Wadden said, there may be a few who clerk, but all of you have been through the system. You have an attachment to it that frankly is not shared by the public if they perceive that it is a gatekeeping exercise rather than a regulatory exercise. So I think we need to be mindful of that. Whenever we change, whenever we make a big decision, we make it based on the best information we have at the time, and we don't know what's going to happen in the future. There are lots of us here in this room that made a decision to marry, fully expecting it to last forever, and found out differently. Or had children and had this vision of what that was going to mean, and in fact found out it meant something quite different. Okay? When we make changes in our lives, when we make changes in our systems, yes, we will have unpleasant surprises, but we may have pleasant surprises if we're monitoring and evaluating along the way. What we have here is an opportunity to begin a change. And it's couched in a way in the majority report that says, boy, if we've made a mistake, we don't have to continue to make a mistake for the next 150 years. We can go back to the drawing board and learn from it. But at the same time, we will have said to those who have been shut out of the profession of law because they can't meet the threshold of article, that we care about allowing them into the profession. We will be saying that we need to find ways, and is this necessarily going to work? We hope so, but if it doesn't, then we will find something else that will work. We cannot do nothing. One of the biggest criticisms that's leveled at the Law Society is that we find it hard to make difficult decisions. I really urge people to have the courage of their convictions and take the best advice that a group of people spent many, many months studying all the options that have since come in droves. They looked at all that and they came up with their best bet. Let's try it. Let's monitor it. Let's have the courage to say if it doesn't work, it didn't work, yes, we spent a lot of money, but it didn't work, we have to find something else. And let's do it without throwing out the system that has worked, as you all say, for so many of you. Thank you.
Thank you, Ms. Boyd. Maître Doyle.
Merci. I support the motion, and today I wish to address 4 issues. 1, Convocation must have the conviction to make the decision today. 2, why we should keep articling, although I've been listening for the last couple hours, and it would seem that most people would agree that articling does play a role in meeting the transitional objectives for training. 3, the flaws in the minority report. And finally, I'd like to talk about the flexibility in the motion that is prepared that will deal with the concerns that everyone has addressed and that we've heard from many outside this room. As a member of the Articling Task Force for the past 1.5 years, I've been involved in formal, informal consultations, countless meetings, study of submissions, animated discourse with all you fellow benchers, fellow lawyers, students, and stakeholders. And after a considerable amount of reflection and rumination on my part, I can say I'm very proud to be standing here to speak before Convocation in support of a motion that will see a study by way of a pilot project which will give Convocation an opportunity to scrutinize 2 pathways. During the project, Convocation, through the guidance of Professional Development and Competence Committee chaired by Ms. Miner, will monitor the implementation of the project and determine policy matters as necessary. Je suis très fière de nos recommandations qui ont été complétées après une enquête approfondie et beaucoup de réflexions et discussions. Nous devrions être très fiers que la profession et autres secteurs de notre société ont été très engagés dans cette discussion. Malheureusement, dans le passé, nous avons attendu que l'occasion notre profession manque d'intérêt dans les questions qui nous touchent. Mais dans ce débat, ce n'est définitivement pas le cas. Au contraire, la profession doit parler et en tant que conseillère, je suis très contente de faire partie de cette discussion. The profession has become fully engaged in this debate because it affects us all and it touches our very essence. And that's why it's inspired vigorous debate. We currently have a 2-tiered system now, those who can find articles and those who cannot. Some would suggest that we go back to the drawing board and that we haven't found a perfect solution. I'm gobsmacked to hear this type of argument. We must end the two-tiered system. How much more time do we need to study this program and what needs to be done? I say to you, soyons-nous courageux. OBA wrote this week, Convocation must show leadership. It must show that we have the right to continue to self-govern and that we show leadership and can decide a motion. Le monde n'est pas parfait, and we need to make a decision today. I had prepared, and you'll be happy to know, I'll shorten my section on transitional training and articling, because I don't hear anyone saying that articling is not the way not a way to continue to discussing transitional training. And I wanted to say, do not throw the baby out with the bathwater, but we've had so many people say it today, so I found another expression: do not throw the champagne out with the cork. And I'm mindful of law pros. 2 submissions they made. One saying that we must go cautiously and incrementally, and in the latest letter, after we adjourned the October convocation, it wrote again that Law Pro wants us to go incrementally. There are insurers, they are concerned if a significant change is made to the articling process, a gradual transition allows any risk impact to unroll over time so it can be absorbed on an incremental basis. And just on articling, one last thing. There have been substantial comments in support for the implementation of quality assurance to articling. The Articling Task Force has discussed this, and in our report we agree. The pilot project envisions measures that provide quality assurance, including more oversight by principals of articling streams. So we've embraced that concern. With all due respect to my minority members that have put together a minority position, it has some serious, serious structural flaws that do not meet the objectives of transitional training. They signed on with the transitional training, the 5 objectives. So there was a unanimous decision as to what the 5 objectives of transitional training. And they're suggesting, number 1, the application of defined practice and problem-solving skills. Tell me how a 10-week course will apply defined practice skills without some form of experiential training. How can those candidates on a 10-week course learn how to apply skills and practice and problem-solving? The second transitional training objective is practice management issues, including business of law. Rien, aucune. There's none whatsoever if you just take a 10-week course. The application of ethical and professional principles, which is the third objective of transitional training. According to the minority report, it would be completed in a static environment with not any real-life setting, and all through some online courses which we currently have as part of our licensing system. But I submit the 2 biggest failings are the socialization, which is when earlier in your career as a lawyer that you get to meet fellow practitioners, and earlier in our licensing process we can have people we meet, whether it's the co-op or through articling. And finally, and this is the one that's most dear to my heart, is the fact that we have systemic mentoring when we have practical training. Mr. Chilcott was my treasurer. He was my treasurer, but he was also my principal. And those people that you meet in mentoring are the people that you continue to socialize throughout your career with, because they become people you can go to. And I can tell you, articling does it. A co-op may do it and will do it, but the minority report does not do it. The final issue I wanted to raise, which has been raised by my fellow benchers today, is that there's some concern that we don't have a perfect solution. I invite you to look at the minority report and how that does not meet what the transitional objectives. But I would like you to also look at our motion. Our motion as drafted shows flexibility. It shows an ability for us to, as paragraph 1B reads, that during the pilot project, data will be designed to enable an evaluation of the project will be collected, and any necessary refinements or other policy issues related to this will be considered by PD&C. 1K3 reads, once Convocation approves the pilot project, PD&C, professional development and competence, will make recommendations to Convocation on the most appropriate approach or approaches for delivery of LPP. We've heard some concerns of the racialized lawyers and equity-seeking groups. We've heard these concerns, and I suggest to you that the flexibility in the motion as currently drafted will be able to meet those needs and discuss those needs. And those include selection of locations, use of technology, program flexibility to accommodate candidates for personal and financial needs, the timing of the offer of the LPP, and society making efforts to avoid any possibility of stigmatization of either pathway. The final thing I wish to say today is that we can debate this forever, and we
No,
need
we're not going to debate it forever.
It seems, and I would encourage everyone, we owe a duty. Our fiduciary duty is to Convocation. Our fiduciary duty is to the society. We need to make a decision. It's not always going to be easy to make decisions, but I think we have enough in this motion as prepared to deal with concerns that anyone has raised here today. Thank you.
Thank you, Ms. Doyle. Merci, Maître Doyle. Mr. Lerner?
Thank you, Treasurer. If this bench intended to engage the profession, I congratulate you all with the 3 issues that we'll be discussing during convocation today. I think the response that we've got from the profession and other interested parties indicates that we certainly have caught somebody's attention. I came in here today intending to support the majority proposal. However, upon reflection, I note that since 1972, when I articled, there have been approximately 9 or 10 significant changes to the articling process. And I would hope that at this stage we would finally get to the point where whatever decision we made would be a change that, looking forward, would have some permanency. What I'm hearing is that both proposals are flawed. Even the proposal of those who spoke to the majority proposal acknowledged that there are frailties in the proposal. And I suggest to you that as many as have been identified, there's the distinct possibility that will be many more that no one has even anticipated or thought of. In my view, one of the biggest concerns I have with the majority proposal involves a leap of faith. And that leap of faith is that there are going to be sufficient co-op placements to place these people. And I have seen nothing to suggest to me that at this point the profession is prepared to pony up to the table and accept co-op students. And given that the success of the majority proposal is dependent upon that, I have some concerns. I hear that people talk about the majority proposal as a start. Frankly, I would hope that it would be the finish, that we would come up with a type of proposal that we can approve here in convocation. I don't expect unanimity in the profession. I don't expect anything that we propose will be universally accepted. But when I hear Mr. Wright, Ms. Rothstein, and others say that they believe that the majority proposal can be fine-tuned within a short period of time, I must say that the strength of their advocacy, the art of persuasion, has convinced me that there may even be a better plan than the proposal that is before us today, and we should be given the opportunity to consider that in a relatively short period of time and come back. Those are my comments.
Mr. Werner, Ms. Hare? Ms. Hare? I just want to remind people that we're running out of runway here. We're trying to call the vote at 12:30, so, and I still have a growing list. So will you please try to keep your comments short so that we can get everybody's views and take a vote. Thank you, Ms. Kerr. Go ahead.
Thank you, Treasurer. My comments are not going to be extensive. I'm going to focus my comments on Aboriginal lawyers' perspective in Ontario, and to some degree Northern Ontario as well, which is where I work. I work in Northern Ontario, mainly Manitoulin Islands, Sudbury, Sault Ste. Marie, and quite often in Thunder Bay. And I can say that lawyers I work with unanimously and strongly can support the continuation of articling. Aboriginal people know what it means to be second-class citizens in this country. But this is not the case, I believe, with either the majority or minority positions in this situation. I agree with Bencher Robstein regarding her concerns about the lack of details with the LPP. For example, a former Bencher, A.V. Gold, would be here advising us to put some of those co-op placements in clinics, and as did Clayton Ruby in terms of criminal lawyers' practices. One of the references I rely on is the Aboriginal Bar Consultation Report, which was undertaken by this Law Society more than 5 years ago now. And part of that consultation report from the Aboriginal Bar in Ontario said that the two most important aspects for them in lawyering in Ontario is networking and mentoring. Aboriginal people, like many racialized and poor persons attempting to become lawyers in this province, do not have connections on Bay Street. What I have found is that the articling experience provides the opportunity for networking and mentoring. However, mentoring has to be further developed and become more concrete, such as Bencher Falconer proposes to us, and I support that. Thankfully, though, this honourable profession of law in Ontario has provided that Aboriginal students are getting articles. The bar exams, however, do need cultural competency provisions within. Finally, the high standards and competency of Ontario lawyers must be maintained. And mentoring first-year sole practitioners is one of the ways that can be done. For Aboriginal lawyers specifically, they must, first of all, know Aboriginal law, and they must apply it to the complex area of Aboriginal law practice. And at this time, articling is the best way to provide that. It is my view that articling must survive, and because the majority position allows all of those who meet the requirements and wish to become lawyers can become lawyers, I support the majority position on this matter.
Thank you, Ms. Hare. Mr. Braithwaite.
Good morning, good afternoon. Not quite sure. Good morning, good afternoon, Mr. Treasurer, members of my fellow benchers, and all those who are on webcast watching. As I sat here this morning and listened to positions taken by many, it sort of struck me when I came, because I had considered a number of things I want to talk about. But as the Treasurer has indicated to us, that let's try not to go over what we've already heard. But I'll just sort of start by simply saying this. I unapologetically support articling for a host of reasons. So it has been said that when we talk about articling, that, and we heard this from really the minority position, that articling doesn't measure the core competencies, or doesn't do it well, or there's no empirical evidence that, in fact, articling does any of these things. The point that I wish to make on that is it just doesn't matter, and it wasn't set up to be something that measured those core competencies. What we have to appreciate when we talk about articling is that it's a complement to the testing. They shouldn't be separated or in any way believe that one size fits all. What we have is, and this has been something that we've had in the past, and what brings in my main concern is that over the years we have been, I would suggest, diluting what we do as a profession. And to the extent that we dilute what we have done as a profession, we have, I would submit, not been so much concerned as we should be with the public interest. What we've had in the past is that we had, for example, we had bar rat examinations. That is testing. We had, and anytime we talk about this particular profession, the people that we're talking about are law students that have gone through years and years of study, years and years of testing. They don't need more testing. But that testing is necessary. There's no question about that. But it has to be complemented by something else. You've been learning. You've been testing that learning. That's great. But you've got to have the articling, because the articling is the complement to all of that testing. It's the actual doing. And that's why we need articling. And with the articling comes all of those intangibles that you can't get by simulation. That's the main crux that I wish to address when it comes down to articling. And we've heard a number of things with respect to articling. People have waxed eloquently on the merit of articling, the intangibles that you get from articling, and I support that. And I won't reiterate those benefits. But there is something that I just wish to talk about rather briefly. And there are three things. One, I just want to briefly talk about competing forces. I want to address the equity-seeking groups. And then lastly, I want to talk about the northern impact. With respect to the competing forces, what I wish to talk about is that what we have heard and the information, and I just recall when we were here on October 25th, Mr. Mercer provided us with some numbers. And he talked in percentages, and I had asked that I be provided with some numbers to back those percentages, and Mr. Mercer was kindly enough to send me those particular numbers. And I find these numbers interesting. I just want to go through them, and we heard a little bit about those percentages this morning. But I want to talk with respect to those percentages and the actual numbers, because I find those numbers somewhat interesting. So we heard that with respect to Ontario grads finding articles, that there may be a crisis there. And we've adopted that there is a crisis. And we heard the numbers, 1,300 drifting up to 2,000. And then we heard the percentages would go with that. But here's something interesting, is because, yeah, with respect to Ontario grads, there were 1,300 Ontario grads that were looking for a job. I'm going to just deal with the numbers as opposed to percentages. Out of that, we've been able to place 1,126, leaving 174 unplaced. I think that's interesting, so I want to remember that number. It's 174 unplaced. That was our best effort in being able to find articles for everybody who graduated out of the law schools in this province. The next group, which we were somewhat successful with, are Canadians coming from schools throughout this country. And what we had coming from other provinces, students coming to firms here looking for articling positions, of 229 of those. And the numbers that I'm talking about are those as of September. So there were 229 students that came to Ontario looking for articling positions. We were able to place another 176 of them. And that number is interesting, because what I had originally told you was that we did not place 174 of potential articling students coming out of this province. But we did have those places were there, because we found enough to be able to put in 176 students coming from outside the province. So those numbers are there. The next group that we have who is seeking articles in this province, as has been said, Australia, the UK, United States. Well, there was 180 of those students that came to Ontario looking for articling. And out of those, we did place 127. So again, there are places. And these were Canadian-born. These would be the Canadian-born students who've gone elsewhere to get their education. The next group, I hear you. The next group was the born elsewhere, the Australia, UK, US. They're not the Canadians, but nevertheless, there was 95 of those. We found articling positions, 46 of them, and then there's the other groups coming from other countries, and these were the ones that were most affected in terms of, and it has been argued, not having that connection with Canada. Again, not Canadian. But out of that particular group, there was 86, and we found positions of 16 of those. What that really tells us at the end of the day is that we have 1,500 places, or been able to find 1,500 places for articling students. And there was 1,900 or so students that we went overall, leaving us with about 400. But the point here is that coming out of Ontario grads, there are 1,300 places that Ontario grads are looking for. We actually are able to establish that we had 1,500 places. And then we had an excess of articling positions. So I ask you to take note of those particular numbers, because they're interested in terms of another way to do things when we talk about articling and finding creative solutions to grow those particular articling positions, because there are places out there. So it may take away from that crisis situation. Lastly, and I'll just take about two minutes of this, Treasurer. I'm just going to...
You've actually gone through more than 5 minutes now, and if we're going to get through this list, you're really going to have to wrap it up quickly. I'm sorry to be rushing people when they want to say things, but a lot of what's being said now has been said, and we really do need to push forward on this. I think people are waiting for us to make a decision. So if you could think about wrapping it up as soon as you can, Mr. Braithwaite, so that we can allow others to speak to the matter, I'd appreciate it.
Do I have 2 minutes? I think I lost duty just on that. I just want to address rather briefly the minority report and some of the concerns I had with respect to that. It made reference to equity-seeking groups, and I have concern about all of that, because I think when you start throwing in equity-seeking groups, that language itself can be somewhat emotional and incendiary, and I think that has to be addressed. What we understand about the minority report, it talks about about 2.5 months of training. I would suggest that when it comes down to equity-seeking groups, that does not address the concerns that equity-seeking groups may have. There's nothing within that other than the fact that there's going to be rigorous testing, which will lessen the barriers for equity-seeking groups. I think it's one thing to advocate the complete dismantling of a system, but you better be certain that whatever you're replacing with is as fair or fairer than what you are attempting to displace. And I have said nothing with respect to the minority report, which suggests that, because it's something that's untested. And there's nothing within that particular program that can equalize or can provide a fairness to equity-seeking groups. The only thing that would come out of that is that we just may very find that equity-seeking groups will find themselves, because it's a fast tracking to be licensed, and equity-seeking groups who can get articles may just find themselves in a position where they're just on the unemployment line that much quicker. And without the training, without the mentorship, without the experience that is needed, so they'll be even less, I would submit, even less prepared to either put up their own shingle or to be able to practice in any particular sense. So you call me a cynic, but I don't see that minority report as addressing any concerns with equity-seeking groups. It would be more a mechanism, as I would suggest, as fast-tracking through a licensing process, which would just ultimately possibly build another faster rate. as I sort of race through some of this thing, is that I'll just finally make this last point. And this last point is with respect to the northern impact. Now, it has been said that if you put them through this particular process, that if you are, that it may be a means of being able to get lawyers into the north and address some of the areas where there may not be access to justice. Well, the reality is that when we have, in the north, when we look for articling students, we're looking for articling students that can, in fact, become part of the culture of the north. So when we get an articling student, they get thrown into the mix rather quickly. They do get that full experience. But the thing is that the beauty of articling is that there's 10 months there that the employers, that the firms can get to acclimate themselves as well as that particular student to working in that area. And at the end, there's 10 months, that particular student either stays or they go, but there's no mark against them if they leave. Whereas if we are going to get students who are after 2.5 months have never had practical training, the problem that we're going to be faced with is that they are not ready. They haven't been acclimated to the north. They may get 1-year contracts. After a 1-year contract, if it doesn't work out, they're going to be terminated. That's an indelible mark. That is not helpful to people in the north, and in fact what would happen at the end of the day is that we'll be left with, if they do get there, the northern firms will be left with having to mentor them, in fact, treat them as articling students when they're in fact lawyers. I thank you for that.
Thank you, Mr.
The time that I had.
Well, actually, it wasn't that brief. But Professor Krishna?
Thank you, Treasurer. Benches, I have kept an open mind on this and have benefited enormously from some of the debate today, and it has improved my thinking on this entire subject. There is no doubt and there is no disagreement amongst this group, majority, minority, and anywhere else in the profession, that competence is the sine qua non of becoming admitted to the profession. There's no debate on that issue. The only debate is really in what route and how you become competent and what is the most efficient way of doing it. And the model that we have is a 19th century model, which we adopted from Britain at a time when there were no law schools. And the two that did exist were teaching canon law and Roman law. And the traditional process of becoming admitted to the profession in the early days was 5 years of articles in which you paid the principal. The articling student paid the principal, because the articling student was just that, a student learning from his, and I use the word his deliberately, master. That, of course, has evolved into the more modern system where there are law schools, and the articling requirement was reduced. And I note that for your information, because it is important, and it's important to some of the comments made by some of my fellow benchers. In Britain, to this day, you do not need a law degree to become a barrister. Indeed, barristers will tell you that they prefer people with non-law degrees because the law degree tends to narrow the mind. And they prefer somebody with a broader mind. To this day. So, all by way of saying, our history industry has changed, and our technology has changed, which makes the demand for traditional articling positions change, and it will continue to evolve. I remember the time when we used to go into the great library there, and there used to be a lot of articling students sitting there in the morning, in the afternoon, and in the evening, doing research for their principals. Go in there now and shoot a cannon. It won't hit anyone, because they're all in their offices doing the same work on their computers. So the structure has changed and we have not. I notice, and I must comment on this, because it is stigma of a different type. We talk about articling, but only in the context of barrister skills. Everyone who talks about it, and they talk about how judges are complaining. And I can understand that. As I look around the room, I don't see a lot of transactional lawyers. I don't see a lot of insolvency lawyers. I don't see a lot of competition lawyers. I don't see a lot of securities lawyers. I don't see a lot of, God forbid, tax lawyers. All barristers, and our perception of the profession is you have to be a barrister. The law clerks do not article. A Supreme Court clerk does not article. And if articling is an absolute sine qua non, I think it was the Latin I heard earlier today, of competence, how do we exempt all the law clerks? Of course, they carry their own stigma. They're labeled with being brilliant and geniuses who must now carry that burden for 35 years and keep proving it every day. There are barriers. Some are subtle and some are not so subtle. And I am concerned about these, not just for the sake of rhetoric, but because of the legal implications that it raises for our law society. Law societies in Canada have been to the Supreme Court of Canada 3 times and they have lost every time. We tried to keep people out on the basis of citizenship, we lost. We tried to keep people out from moving to one province to the next, the black case, we lost. We tried to restrict practice in certain areas, we lost. 3 strikes against us. We have never won in the Supreme Court of Canada on that issue of the nature of restrictions.
Those law clerks.
And I am troubled in the legal sense because of certain comments made. And I'm trying to confine myself only to new issues. The sentiment, only real constraint to entry is articling, is a very dangerous statement to make. Our responsibility is as a regulator, not as a gatekeeper, and articling cannot be a constraint to entry. Otherwise, we may need to answer to the Competition Bureau. There is also an unfortunate tendency to throw dirt at the law schools and to blame them for the problems. The role of the law schools is not to constrain the supply of lawyers. The role of the law schools is to educate. And I am surprised in a society, a democratic society committed to the rule of law, that we would complain that there are too many people being educated in the law. Our role in universities is to educate. The law society's role is to regulate. And there are many people who wish to pursue their dreams and their careers by going to foreign countries because they have no access to the law schools in this country. And they have to go into debt and pay large sums of money to pursue that dream. And they should be entitled to pursue that dream. And I know many of these people who have come back from these countries and who have faced unnecessarily high barriers. Unnecessarily high. People taking a first-class degree from the University of London, coming back, taking 7 courses at the University of Toronto, and still facing hurdles and having to write super exams. And let me read you a letter from a senior lawyer Chairman, for what it may be worth, I fully agree with your proposal that there should no longer be an articling requirement. Well, I may well have changed my mind. But the part that I want to read to you, I look at my grandson who won a scholarship to Cornell, a very good Ivy League school in the United States. And on graduation was taken on directly by White & Case in New York, I think a fairly respectable firm, without serving any articles. He had to run state bar examinations 3 months after graduation. After working for 5 years in New York, he has returned to Canada and was taken on immediately by stipends, but after a year he is still going through all the bureaucratic procedures to be admitted to the law society. Is that a legitimate constraint on entry to the profession we have put up? Those are the people we want to keep out, these terribly competent lawyers. I'm not going to address this issue of stigma anymore. It is too heated an issue, frankly. For those of you who believe that there is no stigma in having 2 classes or in 3 classes, carry on believing it, because I will never persuade you otherwise. But for those of us who have been in the trenches for 26 years with the National Committee on Accreditation, and who have dealt with these applicants of every color, of every race, of every nationality, I can assure you, and we are all the product of our own experiences, that there are issues and they have hurdles and difficulties that others do not. For whatever reason, I'll leave you to come to the conclusion. Now, the pilot program. You know, Moses did not ask for a pilot program to get to the promised land. And I think that pilot program really is not a very, very helpful solution. So what I'm going to suggest, Treasurer, with your permission only, I'm going to ask the benches if they would defeat the majority motion. There is no minority motion, so you don't have to whip it. I will, if that motion is defeated, I will move a motion that the entire matter be remitted to a reinvigorated task force to consider the issue further and in greater depth in light of all of the comments and input that we have received both on this floor and from the profession. But that is entirely upon your discretion, Treasurer, and I will leave that in your hands. Thank you for granting me the opportunity to address Convocation today.
Thank you, Professor Krishna. Ms. Symes.
Treasurer, I undertake not to repeat anything that has been raised today. I want the benchers to go into this vote today with their eyes wide open. We've heard about Section 15.1 and Section 15.2 of the Charter, which underpins our commitment to equality, our vision of fairness in Canada. The measure of the majority report, the only thing that is before us, is not by asking whether or not it treats everyone the same. That's formal equality. But rather, as the Supreme Court of Canada has directed us, to say by looking at the impact of the proposal, looking at the impact of those who go through this new system. You measure outputs. It's called equality of results. And so I ask, before you vote, that you look at the measure of the outcomes. You measure the impact of this proposal. This is a two-tiered system that divides the candidates into the haves and the have-nots.
both begin the process of candidacy in debt. The Law Society's latest figures with respect to debt come from a 2007 survey. The report, which is dated 2008, says that the average debt is $71,728. It's 5 years later. Tuition costs in that 5 years have more than doubled. The economy has tanked, and I think we could take venture notice that the debt load has undoubtedly significantly increased. Both groups go into this process then heavily burdened in debt. And behind the haves door we have, I did a survey, those on Bay Street will be earning this year $1,450 a week. And when I multiply that out, that's $75,000 a year. Now, there are some others in this room whose firms are actually paying $91,000 a year for articling. They provide a full array of health, dental, life insurance benefits. And the firms, as contracts of employment, pay for the articling exams, the licensing fees, all of that. So behind the haves door, we have lucky people with money left over to begin to retire their debt. Mr. Mercer has thankfully quantified that we have 400 in the have-nots. And in the have-nots, what do they face? They face a 4-month licensing course. The numbers are shifting around. Is it going to cost them $7,000, $4,000? Somewhere, probably, hopefully, around $4,000. 4 months of undoubtedly unpaid work placement, if they're lucky enough to get. And I asked Ms. Corsetti this morning, where the women congregate in the women's washroom, whether there was any difficulty for paralegals finding, and they only need a 1-month placement. She indicated that it was, and I suggest that there will be similar problems finding co-op placements for 400 people. And they're going to have to relocate to Toronto or Ottawa for one course. And they're going to face licensing fees not paid for of about $3,000. If you add it up, it is a minimum of $70,000 extra that the motion before us will add to the gap between the haves and the 400 have-not. And that's already on top of their incoming debt in excess of $70,000. Now, who are the 400 have-nots? 56% of them, says Mr. Mercer, 56% of them are homegrown graduates of Canadian law schools. 56% of the 400. And all the rest of them come through the NCA process, every single one. And there's some sort of stigma around about this NCA process. Just want you to think for a moment. You know, these aren't second-class or third-class graduates. And they're not coming from second-class or third-class institutions. We've heard about graduates from Harvard, Chicago, Stanford, at the top of their class. First from Oxford, Cambridge, and London. surely we want these people in our profession. I'm going to vote against the proposal because I think the most objectionable feature to it is that we, the regulator, would be requiring 400 have-nots to work for free. That, I think, is unconscionable. Thank you.
Mr. Ruby?
I'm going to continue to use the concept that Ms. Symes introduced about have-nots, because I think it's important to remember that we are going to be judged not on how we treat those who are the lucky few, but on how we treat the have-nots, how we treat the least of us. And I've been struck in this debate by the praise of articling, because we think of articling from our own perspective, which is privileged. You know, we've risen to the top of the profession. We're here. But we did it because we started off with real advantages. And a good part of articling is just a terrible, inadequate experience. It's not the experience that you had and I had. So between the way we treat those who have bad articles or no articles, and who we wind up leaving behind, disproportionately identified by race or foreign origin or that peculiar academic way of coming into the profession, it is not an acceptable result to the public to discriminate in this way and have two tiers of assessment process going forward, and it should not be enough for us.
Thank you, Mr. Ruby. And thank you, Mr. Ruby, for being brief. Mr. Sullivan.
Thank you, Treasurer. Regional venture from Central South, and I can report to Convocation certainly that the lawyers in my area strongly support articling, as do the lawyers from the province, across the province. I was going to make some comments to remind Convocation, but especially those members of the profession who are watching, about the extensive nature of the consultation that we went through. As my colleague Adriana Doyle outlined, there is nothing further to study. I just wanted to make one final comment. If we don't make a decision today, we're going to have the status quo. There'll be no decision made. The 300 to 400 to 500 people who are not getting licensed will be blocked. Thank you.
Thank you. Thank you very much, Mr. Sullivan. Mr. Chavis?
I think it's been said, but it perhaps bears repeating, that the abolition of articling is not before us today. Not today. Some of it, of course, wish it were. It's clear there's not the support for it in this room or in the profession. Just as there wasn't in 1972 when Mr. Robbins and so many others took the same view as the minority, that when you take a truly hard look at it, it cannot be justified. But it's up to us to take those hard looks, sooner or later, whether it really achieves all of the benefits that some believe it does, and have stated so today. But that's not why we're here today. But the issue of articling does raise fundamental questions about our licensing process and the fairness of our licensing process and what it can actually achieve. I'm not here to repeat what I said last day, nor do I wish to turn this into a reply to others. I do wish to just make a couple of comments with respect to the issue of two tiers and discrimination. My colleagues or recent speakers have already touched on that. I did find, though, that there are so many views in this room. There's so much discomfort, frankly, in this room about the majority proposal. And people all come at it in different ways. I found it interesting that Mr. Anand criticized the minority's proposal to mentor, arguing that it was somehow stigmatizing. I frankly found that extraordinary. I rather preferred Mr. Brett's approach, who also supports Mr. Anand's motion, who argued compellingly for mentoring and the need for mentoring. And I thank him for that. I couldn't have put it better myself. Unfortunately, it's not part of the majority plank. It should be. It should be something that we should be test driving if we're going to be test driving things over the next few years. It's something we could do if we listen to Ms. Rothstein and Ms. Leeper and others and go back and work a little harder on this. At last, the majority, in response to the comments we made last time, has suggested, well, it might be 3 years. Might be 3, could be 2 more. At least it's some recognition that it wasn't a true pilot. There are concerns as to whether this is really a true pilot, and rightly so. But if we're going to do a pilot, why not create a short, attractive program as an alternative? Why not test drive a real alternative that's attractive to those who can't get articling jobs, rather than burdening them with the burdens that Ms. Symes has so clearly set out? Why not test drive that? Why not test drive mentoring, as we should, as we've all agreed we've got to do more on mentoring, and come back really soon with the benefit of the debate, the benefit of this debate. We can go back and do that. We've had the benefit of this debate. We've had the extraordinary benefit of the impact of the profession. And as Ms. Boyd said, we could really do with some more impact input from the public on this. And so I say, as I said before, that you should defeat this. You should send us back. You should urge us to do better, and we can do better. Thank you.
Thank you, Thank you very much, Mr. Chavis. Mr. Wardle?
Treasurer, fellow benchers, members of the profession, licensing candidates, I want to begin, first of all, by thanking my colleague, Ms. Miner, for her very kind comments this morning. It's not easy to dissent in this body. It hasn't been easy for us. We took the position we did as a matter of principle. We did not expect in August that the profession would support the abolition of articling, and we do not expect that now. And that's why there's no motion on the floor from us to abolish articling. So with respect to all of my colleagues this morning who have spoken passionately about articling and whether it should stay or it should go, that's not the issue before you today. The issue for you today is whether we proceed with the majority proposal. And our concern, and I want to be very frank about this, my personal concern over the last few months has been with this proposal and whether we could make it better, because in the minority we understand that articling is not going to be abolished and there is going to be some form of pilot. So first of all, I want to say I'm gratified that there have been some small improvements. 5 years has been changed to 3 years. And I'm gratified for that, because it's a sign that at least some of the people involved in this process have listened to us. And I'm also gratified by Mr. Faulkner's motion, because I think it's overdue, the recognition that the profession needs to contribute to what we're going forward with. But in my view, and I have to say this with respect, we're not there yet. We are not there yet. And we should not be comparing the 300, I have it as 300 students currently. We shouldn't be comparing the position for those 300 who can't find an articling job with the situation where they started. That is, that they can't get through the licensing process at all. That's a false comparison. We should be comparing the majority proposal with what other alternatives there might be out there available that are better. And that takes me, as it took Ms. Symes, to the co-op. And I frame the question around the co-op as this. Will the students going through this pathway be perceived Will the alternatives be perceived by the candidates and by the bar as real alternatives, or will the LPP simply be a second-best alternative for those who have to take it? And it seems to me that that's where we fall down. And with due respect to my friend Ms. Minor, with respect to the co-op, it is essentially blue sky. We don't have any assurances with respect to quantity, and we don't have any assurances with respect to quality. We have a lot of hopes in this room, but we don't have any assurances. We don't even actually have any data. And with respect to quantity, we are going to be telling the profession that we've solved the articling crisis without knowing if we can find those 300 positions. And what are we going to do? What are we going to tell the profession if, in fact, we can't find them? What will we say then? So, in my view, at the end of the day, and I add to this, as Ms. Symes did, these positions, we all seem to be in agreement in this room that these positions are going to be unpaid. Would you take a law student into your office who offers to work for free? I would not. And I've been in that situation. I had a student approach me last year who couldn't get a job after completing the licensing process and wanted to work for free. We took him in our office and we paid him. So why on earth, as the regulator, are we going to have a sizable group of candidates going through our licensing process who are going to work for free? In my view, and I'm summing up, bearing in mind the time, how can we be satisfied that this group of candidates will not be stigmatized? There are alternatives. We have started to explore the alternatives. There has been a debate going on behind the scenes. But to be frank, we haven't had time to finalize where we could go with the alternatives. We could get rid of the co-op. I dread saying it out loud, but we could get rid of the co-op. And if we got rid of the co-op, the process would be a lot shorter, and it might actually be an attractive alternative for those going through articling. And if the LPP became sufficiently attractive to candidates, it would no longer be stigmatizing for them, and the perception that the profession would have about the alternative would be entirely different. So I must say, at the end of the day, I support the position taken by Ms. Rothstein. We haven't given this enough time. You should vote to defeat this motion. That doesn't mean we can't continue to build on what's been done, but the current proposal in my submission is sadly flawed. Thank you very much.
Thank you, Mr. Worrell. Mr. Robbins? Who was the treasurer the last time there was a proposal to abolish articling? Yes, I'm reminded that many went to the Court of Appeal.
Well, thank you, Mr. Treasurer. I've been around these quarters, as you know, for many years. And over that time, there has been no subject that has been discussed more and with more emotion than the subject of articling in legal education in Ontario. The subject has been visited and revisited. And I can go back behind the 1972 report. I was here in 1948 or 1949 when the benchers made a colossal error and decided that 3 years of articling was what was required, and the law school was simply a trade school. And that led to the resignation of Dean Wright and for Alaska and John Willis and others on the faculty. The only good part of that was it led to the appointment of me as lecturer at Torrance at the time. You made reference, Mr. Treasurer, to 1972, and I just want to say a word about that because a number of benchers have spoken to me about it. And I had the opportunity to read the 1972 report for the first time in 40 years, in preparation for the last convocation. And in reading it, I was amazed at how the issues were virtually identical to what they are today, and how the discussion was almost the same as what it is now. There are differences. We didn't have as large a profession then. We didn't have the same dire circumstances we have. There weren't as many students who couldn't get jobs. We didn't have paralegals at that time. But essentially, the issues were the same. And we established earlier a Blue Ribbon Committee, which consisted of not only benchers, but representatives from the courts, from the law schools, from the senior and junior bar, from the community, from students, and all unanimously agreed that articling should be abolished. Well, I can tell you that I was in that chair when this report was presented, and it was, to put it mildly, not well received. It went over like the proverbial lead balloon. And it became apparent, there were some other recommendations in there that were eventually enacted, but it became apparent that there was virtually no support in the profession for the abolition of articling. And notwithstanding the word that's always used is unevenness in the profession. Now, I heard someone say earlier that Mr. Chilcott was her principal, or Mr. McKenzie was the principal. Well, sure, there are very good articles that can be had, but the process itself is uneven. And it ranges from the excellent to perhaps the good, to the fair, to the bad. And I was amazed when we had that 1972 report, because prior to it, there were all sorts of complaints about the quality of the articling process, the menial tasks that students were being asked to perform, about, the word was forced labor or slave labor that students were was expected of students. The moment the report came down, we were taking away some God-given right to articles. So, Mr. Treasurer, I've grown too old and too tired to talk about the abolition of articling any longer.
And so have I.
We're all in this process. We have to rationalize. Once we were, I don't recall, I checked my memory as best I could, and I don't recall any debate at that time in Convocation about the report. We enacted some other aspects of the report which were motherhood issues, but we never got down to a meaningful debate on articling because it was apparent that it was a non-starter. And I see, I looked up a clipping that I have at the time, and in a press conference I tried to put a good face on the matter. I said, we've just undergone an intensive and exhaustive study of legal education in Ontario, said Sidney Robbins, the Society's treasurer, and the majority of us are convinced students must receive some form of practical training. He added the main complaint about articling was that it was uneven, and while some students receive good training, some don't. Then it goes on. In an attempt to improve the articling system and raise the minimum standards, a special articling officer has been appointed to assist students and offices they work in, Robbins said. And in addition, the Society will continue to search for better methods of giving students practical training. Well, 40 years have gone by since then. And I suggest to you, benchers, that we don't know any more after these 40 years about the articling system than we did then. the system is just not susceptible of any objective analysis. You can't get into someone's office and examine the relationship between the lawyer and the student. So some people will have, as we say, good articles. They will have the social aspects of the matter. They'll have the fun of it. They'll be dealing with real problems, real lawyers. They'll remember their first case in small claims court. And it's an experience that they look back on with pleasure. And the bar in Ontario has come to love the articling system. And like true love, we love it with all its imperfections. But you can appreciate, in light of that, the position that the committee was in when it was confronted with the problem that we have now. The problem is much more acute. We've got, what I understand, is 20% coming up. That's 1 in 5 lawyers, 1 in 5 students who won't be able to get jobs. So what do you do about it? The committee has come up with a compromise type solution. And having been through this, I have the greatest respect for what the committee sought to do. But I have to tell you that I have some concerns about what has been proposed here. It's not in my nature to talk about discrimination, but we have to recognize, candor requires us to, that discrimination is no stranger to the articling process. I remember all too well the problems that my co-religionists had in obtaining articles. And there are different focuses or objects to discrimination today. It's no accident, and it's not coincidental that the Black Lawyers Association, that the Asian Lawyers Association, that other equity-seeking groups favor the abolition of articling because they fear that they are the ones who are going to be the second-class citizens in this matter. They're the ones who are not going to get the articling position, or certainly in a higher proportion than others. I have read, I should say perused in some cases, most of the material that was submitted. And it's interesting to note that it's not only those equity-seeking groups that have taken that position, but you have more establishment groups like the Advocate Society and some university professors and general members of the public, or the profession rather. I don't know who they are, but they sound like sensible, reasonable people. And they're concerned about the inequities. I took down some of the words that were used. The unfairness, the unreasonableness, the two-tiered licensing system, the fact that those who take the LPP will be considered inferior, the risk of prejudicial two-tiered licensing system, and the other criticisms that we have of the system. Now, I don't know what to do about it. You've made a proposal, and my concern is that the proposal operates to the disadvantage of the people who are in the LPP program. That you might ask the question, who gets the articles and who doesn't? Well, the good students, the top students, they'll get articling positions. The good students will. Even the average students will probably get articling positions. But when you get down to the poorer students, when you get down to the students who are
are different in terms of their ethnicity or their background, they're the ones who can't get the article. And they're the ones who are going to be relegated to this new system. I could understand it if we had a competitive system, that is, an LPP system that competes with the articling system, so that students who are contemplating, who want, they've gone to school for 5, 6, 7 years. They want to be full-fledged lawyers. Some of them aren't going to practice, but they want to be full-fledged lawyers. I can understand if they say, well, I've got this alternative, I'll take it. I'll take one or the other. But frankly, I can't see any student who's able to get an articling position choosing the LPP system. It doesn't seem to me something that's feasible, something that's practical, something that they would engage in if they have their druthers. So that's my concern, Mr. Treasurer. My concern is that this program, as it's presently devised, is divisive in the profession. You're going to have, let's just reduce it to cases, or a case. You have two students. They're both about the same. They're both about average students, or they're both poor students. But one of them has family connections. He has some pull. He has a father maybe who's a lawyer or a judge or a business person or somebody who's a user of legal services. They'll get the job. The other guy, he's not going to get a job. So surely there's going to be some jealousy. There's going to be some discrimination. There's going to be some feeling as between the two of them. There's no rhyme or reason as to why one should be getting the position and the other shouldn't. And there's no option. There's no option at all. I kind of visualize this as we call it the pathway to a license. And you're down the path, and you come to a fork in the road. And on that fork has one direction, you go to article. The other one, you go to this LPP program. Now, nobody who doesn't have to will go to the LPP program, if I'm right. Maybe I'm overstating, but I'm not as close to the profession as I used to be. But I can't see them doing that. So what I suggest, Mr. Treasurer, is that if we're going to have an alternative program, then it be one that's competitive. Competitive in the sense that the student who comes to that fork in the road can say, well, I could article if I like. Maybe I've got good articles. Maybe the guy that's offered me a job is a first-class jerk, but I can still get articles with him and complete my 8-month period. But I'd rather take the other route. If there's something there that's attractive for him to do, so that it's not just the losers. You know, there's an element of a crapshoot about this whole thing as to who gets the job and who doesn't get the job. And I think we have to have, in fairness, we have to have something that makes the alternatives some element of option. Some option involves freedom of choice. That when you come to that fork in the road, that you can go either way. Now, Mr. Treasurer, it's often been said, and I agree, that the Law Society has no responsibility as to the number of lawyers who are graduating from the law school. That's not our function. That argument has been raised for years. I've always been amazed at the students who immediately upon graduation are the first to stand up and say, close the gates and don't let any more in, at least not for a while. But that's not our responsibility. But our responsibility, I suggest, is the responsibility to provide an opportunity for licensing for all those who have achieved the academic qualifications necessary to be a lawyer. And we, I think, fall short in our responsibility if we don't provide that. And I know that that's what the committee is doing. And anything I say that might be interpreted as being critical of the committee, of the committee's decision, is meant to be because I know how difficult this whole issue is. But in pursuing it, I suggest to you, Ventures, that we have to have all of the students. We have to have a fair, an open system. We have to have one in which equality and justice prevail. Those are hallmarks of our profession. And we can't have that if some group in the profession is going to be disadvantaged because we're running a team A and a team B, and they're on team B. I don't think that's something that we as a society, I should say one more word. I appreciate that what I'm saying in terms of what might be called tolerance in the profession is something that doesn't apply it applies in the articling process and it applies later in the job-seeking process. But there's a big difference. We're not part of the job-seeking process. But we can't sanction, I suggest, a process that puts some students at a disadvantage over others. We have to provide a level playing field in which all students have an equal opportunity to get their license. Those are my submissions.
Thank you very much, Mr. Rollins. Ms. Murchie?
Thank you, sir.
So let Convocation know that I have, after Ms. Murchie, we have three or four other people on the list. We shall be taking a vote soon. Yeah, we've blown right through 12:30.
12:30 PST.
So we're trying to go for 1:30.
Treasurer, thank you. Treasurer, I wanted to speak to the proposal from a number of benchers that urge us all to reject the majority report and go back to find a more perfect system, in the words of Ms. Roski, or to consider other options, in the words of others. As this convocation knows, the Arctic and Task Force has spent 18 months on this particular consultation, on sorting out what the options might be, and considering the options and speaking to colleagues and attending sessions all over the province and in speaking with venture colleagues as well. We've considered many options, not just the 5 options that were put to a convocation in the context of the report that was released last December. And a number of those options were rejected after much discussion and did not go forward. And I can tell you that the proposal that Mr. Mackenzie puts forward is something that we did consider in another forum or in a general way. We talked about subsidizing or paying or creating for articling positions that would allow us to maintain articling as the only option. And we really ended up coming to the conclusion that this was not a viable option for a number of reasons. And to the best of my recollection here, one of the reasons was we thought that it was awfully expensive. If we assume that we know there's approximately 300 students without positions, if we were to create jobs, even at $25,000 a job, That would be almost $8 million. And there would be administration fees involved and other employment costs. And that's 10% or more of the Law Society's budget and would require an increase in fees, a corresponding increase in fees. That's on the basis of 300 positions, and that's at a $25,000 subsidy. Someone presented the average articling salary as in the $50,000 to $75,000 range, I think, at some point. So we thought that that was a big price to ask our members to pay, particularly because a lot of them already hire articling students, and none of them, as we know, hire articling students as profit centers. They hire articling students for a number of reasons, including because they think it's part of their obligation to the profession. It seemed to us extremely unfair that we should expect a great part of the profession to pay for their own articling students and then subsidize the hiring of articling students by someone else. There was also a concern as to how the Law Society could realistically choose who to subsidize or what positions to subsidize and what positions not to subsidize. And there was another concern that it could very well reduce the number of positions that were available because firms say, wait a second, I'd rather have a subsidized position. So for a lot of those reasons, we just concluded that it was not a realistic option to put before Convocation. Now, the more perfect system that is suggested that we ought to go back and consider, more perfect is different to every single one of us. And we already know that. You've heard how we've consulted with the profession. Everybody has a slightly different take on it. Mr. Campion thought it would be useful to have essentially the bar admissions course brought back in. I happen to personally agree with them. Some in the room think that articling ought to be abolished. There are a lot of different, more perfect solutions that can come from around this table. But what we tried to do in coming forth with the majority proposal is present something that addresses the issues before us. And just before I go on to why we really think that this works, it seems like the co-op placements are a big issue to a number of the people who urge you to put off this decision for yet more study. I guess that there are several responses to that situation. First of all, the Thunder Bay Law School, the dean has made it very clear that he fully expects to be able to obtain co-op placements for his students. At Osgood, we have Osgood Law School coming up with an experiential learning course, and they are obtaining and expect to continue to obtain placements for students at the present time. Now, Ms. Rothstein said, why can't that be counted as a co-op placement? And if you look at the majority report, you'll see that we do talk about the Carnegie model, which envisages exactly these kinds of experiential learning experiences to come from within the law schools themselves. And we're quite open to considering those kinds of placements as a co-op placement. We just haven't got anything in front of us to look at it to allow us to assess it at this point in time, but certainly that's a real possibility. And I think if the report doesn't make that clear, it should. We've also had interest expressed from a number of not-for-profit groups in taking advantage of the co-op placements. We also know that a lot of the smaller practitioners or sole practitioners that might be interested in taking articling positions are not in a position to afford an articling salary. And we had just some informal interest expressed from potential service providers, and none of them thought it was a problem. Co-op placements are something that is obtained in the context of training professionals in other professions, and the thought was that was something that could be dealt with. So no, we don't have 300 positions in place right now. But we have some very good information that leads us to believe that that's available. And that's the basis on which we're confident in coming to Convocation and presenting a program that has some potential, a great potential, for succeeding, and succeeding very well, in our view, to allow for the training of a competent profession. One of the bloggers, or the Twitter feeders, in the earlier Convocation session that was broadcast, said that the majority seemed to be most concerned with competence and the minority most concerned with fairness. And we are. Our key focus has been competence, because that's what we think is the regulator's function, the regulator's key function. At the same time, we recognize we have to have a system that's fair. So let me just talk for a minute about the significant advantages of the articling of the proposal being put forward by the majority right now. First of all, the first advantage that we see is that this dual pathway we're putting forward today, it strengthens and consolidates our standards, our competency standards, which we see as being in the public interest. Articling is retained, but it's been improved. That's the whole point of it. We're improving it to remove the inconsistency. We know it works. The profession has told us it works. And there's no evidence, simply no evidence, that abolishing articling will mean equal or more competent lawyers are produced. The proposed LPP is new, but it'll combine 4 months of intensive training with a co-op program that we are intending ought to at least incorporate some of the experiences of articling. And we believe and we intend to make sure that this combination will provide an excellent practical training for students. And at the end of all of this, we have incorporated an assessment for students, an assessment to make sure that students have the practical skills that we identify as necessary for practice. So we see this as an opportunity to strengthen the standards of the profession and to promote competency within the profession, which is definitely in the public interest. Now, let me talk for a minute about the fairness issue. The perceived barriers to entry created by the current system included the two kinds of unfairness that were identified in the report. First of all, it was the inconsistency in the articling process. Now, for some it's good, for some it's not. And the inadequate placements in smaller firm situations or alternative practice positions. The inconsistency problem we intend to solve by improving articling, as we've set out in the report and has been discussed and I won't go into again. The creation of co-op placements is something that's important to us. It allows for a variety of practice experiences within the context of the articling model or within the context of the co-op situation. Now, the minority, and so we feel that we've addressed some of the real fairness concerns that are identified by the report as creating the perception that the articling process in its current form is an unfair barrier to entry. Now, the minority says that articling is an unfair barrier to entry because there's simply no evidence that it works, no objective evidence that it's effective or that it's necessary. And our response has been, as I think all of you know at this point in time, that we do have evidence that it works. We have evidence from the profession. It's simply, it goes without saying that the bottom line is there's no evidence that the system that they propose will promote confidence within the profession. The third and last point I'd like to make is that the proposal that's coming before you today, it creates a terrific opportunity to set further standards for practical training. First of all, it allows us to define what standards we think are important for entry-level competency and to test and see if those competencies are achieved. Now, That's important for us for a whole number of reasons. We've let that go to some extent within the context of the articling process, and we're going to reinstitute that and assess and determine, sort out, I know there will be discussions with Convocation as to what competencies we think lawyers need in order to start in the profession. So it really gives us a great opportunity to set those standards, and as the regulator, that's our obligation to do. We're also pleased to say pleased to look at an alternative model for practical training, and one that we're confident will work. But what we're proposing also allows us to gather some data on the effectiveness of both systems. And we've not had that before. I guess the last part of this, allowing us to set the standards, is important because it lets the law schools know what we're looking at in terms of training requirements for lawyers. Thunder Bay, as we've said, is already looking at incorporating practical training within their law school experience. And I think we're hopeful that by setting out the standards clearly and strongly right now, we will encourage more law schools to look at that option as well. We can't say if it's going to work or not, but frankly, that would be the ideal alternative for many, many of us around the table. And that is something that could result in this. So although there are problems that have been identified, and I think that the majority has very strongly refuted those problems, we think that the opportunities that exist with this system are really important opportunities that we shouldn't miss. We should be looking at the advantages that we have with the current proposal, rather than in focusing on trying to nitpick, fine-tune to a more perfect system that is different in everybody else's mind. So I urge Convocation to make the decision today. There have been, according to Mr. Robbins, 50 years of deliberations on this issue. We actually have a system, a proposal put forward that addresses a lot of the concerns, most of the concerns, and it's one that we should be voting on.
Thank you, Ms. Murchie. I'm going to ask the last speakers to please, we're getting very short of time, so Mr. Silverstein.
Treasurer, I pass.
Thank you. That's very, very helpful. Thank you. Mr. McDowell. Mr. McDowell.
Monsieur le Trésorier, si vous me permettrez 2 minutes. I support the majority position, mais quelques aspects du rapport de majorité m'inquiétaient. C'était un programme de pilote de 5 ans qui me semblait trop long, et le coût estimé pour les candidats dans un programme pratique posait une barrière lui-même. But the debate that we have had, sous la lumière du débat, I think has been very helpful in shaving off some of the more difficult parts of the majority report. I think the idea of making it a 3-year pilot makes eminent sense. And even though it will not be universally popular, I think the idea of sharing the burden of cost among members of the profession as a whole is a good thing. And so I support the motion. Now, there are things in the speeches which certainly have given me pause. Mr. Robbins' concern about discrimination and inequality between the two streams troubles me. Ms. Symes, Mr. Ruby speaking about the have-nots and the injustice of their position has troubled me. But at the moment, and Mr. Mercer said this the other day, the have-nots have nothing. And that's the point from which we have to begin all of this. So we have fixed points in the debate. One is we've got the have-nots having nothing. The second one is, today in American Thanksgiving, the profession is not prepared to go cold turkey on articling. And I have thought that all the way through this debate. Intuitively, Mr. Robbins, looking over the long sweep of history, assures me that that's true. So it appears, as Mr. Sheva says, there's not support for the idea of abolishing articling. It's not on the table. So we move forward. But I simply wanted to end with this, that I congratulate my friends on the minority side for the force and the clarity of their report. I really do. And I thank them because I think we have a better solution than we had without their input. And frankly, I think it has to become easier to dissent in this room, because I think when we have that element of dissent, we come up with better solutions. And so as we move forward, I'm anticipating a little bit here, but as Mr. Brett says, this is not a situation where we have anything except the end of the beginning. And if we're going to have a system which is workable and is fair, we are going to need everyone in this room working in one direction. And I implore my friends in the minority to be on board, and I implore all of us to let them on board, and let's go forward together. Thank you.
Thank you, Mr. McDowell. The last word before Mr. Mercer. Mr. Mercer first, and then Mr. Anand will sum up. And we'll put the vote.
I have two things that I want to say. The first is premised on what must be the reality known to us all, that articling will not end as a result of this process now or in the next while. The second reality is that there are 300, 400 people who can't find jobs, can't find articles. So we can have one system where everybody is the same, which is you article or you don't get licensed. Everybody will be the same. 300 to 400 people will pay the cost of that. The second alternative is to have an alternative pathway. And the essential argument, which is put by Ms. Rothstein, put by Mr. Shabas, put by Mr. Wardle, is that that should be made attractive so that it's competitive, to use Mr. Robbins' phrase. How is it made competitive? It is made competitive by it having no experiential training, no practical training. As proposed by the minority, it is 5 weeks of in-person classes, 2 weeks of remote training. It's more attractive for a candidate. It's lousy once you get out in practice, and it's lousy for the clients of those candidates. Those 300 to 400 people who can't find articling jobs will be our new sole practitioners. They will be struggling with the 150 to 175 who are already out there. And I say with passion, it is no fairness to those people to give them a really attractive licensing program to abandon them in practice. And I say that our greater obligation of public protection, which is our core obligation, is that which should resonate for you all. And so I ask us, as passionately as I can for a quiet fellow, don't do that because it won't work. We have great broad principles that we all agree in, but sometimes we have to look at practical alternatives, and we have to look at the practical implications of our practical alternatives. By postponing this vote, that difficult choice between the three prospects, only article with an LPP that's really attractive, and articling with an LPP that actually protects the public and the candidate, those choices must be made today. And for those who hear the siren call of tinkering, who think that if we simply work together, that we're going to work out the rough edges and come to some happy day where we all agree because the differences are small, they're not. In any complicated proposal, any complicated system, there is a coalition against if we each hold out for our perfect version. It's often said the perfect is the enemy of the good. In a complicated proposal, it surely is. What you have to do, in my view, is to descend to the vernacular, suck it up and make a real choice. It won't be perfect. It'll get better as we work it through. But whichever of the three you're in favor of, vote for it now. Don't just hope that a better bus will come along. It won't. And so for those who are in favor of what I believe is the most fair, that protects the public, vote yes now.
Thank you, Mr. Mercer. Mr. Anand.
Thank you, Treasurer.
With thanks to our colleagues for an enlightening and thoughtful debate, it remains only to me to reiterate that the motion is in paragraph 1 of the materials as amended by paragraph A, which was introduced today, and it's moved by me and seconded by Mr. Mercer.
Thank you, Mr. Anand. We are going to take a roll call vote. So everyone has the motion from us, made by Mr. Anand, seconded by Mr. Mercer. Mr. Farrell will take a roll call.
Mr. Anand?
For.
Ms. Backhouse?
Again.
Ms. Boyd?
For.
Mr. Braithwaite?
For.
Mr. Brett?
For.
Mr. Callahan?
For.
Mr. Campion?
For.
Mr. Chilcott?
For.
Ms. Dixon?
For.
Ms. Doyle?
For.
Mr. Dre?
For.
Mr. Earnshaw?
For.
Ms. Elliott?
Against.
Mr. Epstein?
Against.
Mr. Eustace?
For.
Mr. Evans?
For.
Mr. Falconer?
For.
Mr. Ferrier?
Again.
Mr. Gold? Mr. Goldblatt?
For.
Ms. Hay?
For.
Ms. Halajian?
For.
Ms. Hare?
For.
Ms. Hartman?
For.
Ms. Horvath?
Against.
Mr. Hunter? Mr. Krishna?
Against.
Ms. Leeper?
Against.
Mr. Lerner?
Against?
Mr. McKenzie?
Against.
Ms. McLean?
Against.
Mr. McDowell?
For.
Ms. McGrath?
For.
Mr. Marmer?
For.
Ms. Matheson?
For.
Mr. Mercer?
For.
Ms. Minor?
For.
Ms. Murchie?
For.
Mr. Porter?
For.
Ms. Potter?
Against.
Mr. Festina?
For.
Mr. Rabinovich? Ms. Richardson?
Against.
Ms. Richer?
For.
Mr. Robbins?
Against.
Ms. Rothstein?
Against.
Mr. Sandler?
For.
Mr. Scarfone?
For.
Mr. Shavis?
Against.
Mr. Sakan?
For.
Mr. Silverstein?
For.
Ms. Strasburg?
Against.
Mr. Strasburg? Mr. Sullivan?
For.
Ms. Symes?
Against.
Mr. Wadden?
Against.
Mr. Wardle?
Against.
The vote is 36-20 in favor of the motion. The motion passes. Thank you very much, everyone, for the debate this morning. And thank you all very much for sticking to your 5 minutes. We have order, please. Order. We still have a motion to deal with that has been brought by Mr. Faulkner and seconded by Mr. Goldblatt regarding the commitment to the profession's commitment to the licensing process. I'm in your hands. We can deal with it now, or we can deal with it when we come back from lunch as a first order of business. Okay, we'll call the vote. Do we have the wording? Okay, I'm advised that you must move it, Mr. and I mean in both senses, move it. And move it, and Mr. Goldblatt will second.
Mr. Treasurer, you will be not calling you to lead on that?
Oh, well, I don't get the sense in the room that...
Oh, I have something to say.
You have something to say about it? Okay, well, we'll see. Is there anyone else that wants to speak to the motion? All right, so we'll...
I would make very brief introductory comments and listen to see if there's anything else, and I'm in your hands, Treasurer, and I'll be moving quickly. Treasurer, you will appreciate that we've been through a very lengthy debate, so I'll make this very short. We have made comments in the past about the importance of articling, and I say that we have to put our money where our mouth is, that we have to share the burden that we are now going to impose on our new candidates. I have amended the wording of the motion to be consistent with the reality that we do not have cost numbers now, and without cost numbers, the exact extent of the contribution by the profession is being left to the discretion of the Professional Development and Competence Committee.
Someone on the line is not muted.
Yes, the sound call here.
Yes. Could you please star 6, Mr. Gold?
Star 6, please.
Star 6 or hang up. Turn it off. Mr. Gold, could you please disconnect your... We can't hear... Mr. Gold. Thank you.
In the circumstances, Mr. Treasurer, what I propose in respect of the motion now reads as follows, to be found at page 382 of Board Books, tab 9, that in recognition of the necessity to defray the cost to licensing candidates of the licensing process, Convocation shall approve an appropriate member contribution to the costs of the pilot project to be recommended by the Professional Development and Competence Committee once the costs of the pilot project are determined by that committee and recommended to Convocation as a matter of implementing the pilot project. It's seconded by Mr. Goldblatt.
Can I get a clarification, please? Will that still have to go through audit and finance in order to be approved? It doesn't talk about that, just talks about PD&C.
The motion is crafted so that it will not offend the process that we follow for any kind of monetary Somebody apparently finds that amusing. Whoever is on the phone, would you please disconnect? Whoever's just not on, please disconnect or press star 6.
A motion having been placed before you, Treasurer, seconded by Mr. Goldblatt, given the time that has been put into the debate, an obvious essential feature to what we've just passed, I would respectfully submit, is the promise to assist in funding. So I put it to you with the hour and how hungry everybody is. I'll simply wait to hear comments to respond to if they are there.
Mr. Callahan is the only one on the speakers list. He's the only one on the speakers list.
I will be short.
He's the only one on the speakers list before lunch.
I know, but I'll be short. When we came to Convocation, the new bench came, the first thing we heard was the treasurer talk about an adult conversation. We had an adult conversation. We need another adult conversation. You're going to hear from the Finance Committee that that Convocation is overspent by $8.4 million on an operating basis a year. We are using our reserves. That cannot continue. And we need a discussion about priorities and what we're prepared to spend and how much we are prepared to charge our licensees. And so when we come and say, oh, we're going to commit to pay for the pilot project without having that debate is frankly irresponsible. That debate has to happen. This motion may well be valid. It may, amongst the priorities that we have, be the most important. But it's something that we need to consider now. With the $8.4 million in deficit financing that is being done out of our reserves, we are hitting our own fiscal cliff. And I say, do not
pass this motion now, wait to have a fulsome debate as to what our priorities are and how we're going to deal with our financial problems in this House. That's what I have to say on that.
Thank you, Mr. Callahan. Ms. Hartman, Mr. Callahan, as everyone knows, is the Vice Chair of Audit and Finance. Ms. Callahan, Ms. Hartman,
Ms. Hartman's a good-looking, smart one.
Ms. Hartman,
Thank you.
Can you please go to the, this is
Yes.
still being one.
Thank you, Treasurer. As co-chair of the Audit and Finance Committee, I rise in support of this motion. As the Treasurer alluded to in his comments, this motion will be properly vetted, not only by PD&C, but by Audit and Finance, as well as I understand by Equity. I want to remind everybody in this room that by this motion, we cannot bind Convocation to commit to a future position. And that's why I don't hesitate to support this motion. Thank you.
Okay, can I call a vote?
Yes.
All in favor?
I'd like a roll call, sir.
Yes, roll call vote. Thank you, Mr. Chavis. That's appropriate, I think.
Mr. Anand?
For.
Ms. Backhouse?
For.
Ms. Boyd? Mr. Braithwaite? Mr. Brett?
For.
Mr. Callahan?
Yes.
Mr. Campion?
Against.
Mr. Chilcott? Ms. Dixon?
For.
Ms. Doyle?
For.
Mr. Dre?
Against.
Mr. Earnshaw?
For.
Ms. Elliott?
For.
Mr. Epstein?
Against.
Mr. Eustace?
Against.
Mr. Evans?
For.
Mr. Falconer?
For.
Mr. Ferrier?
Against.
Mr. Gold? Mr. Goldblatt?
For.
Ms. Haig?
For.
Ms. Haladian?
For.
Ms. Hare?
For.
Ms. Hartman?
For.
Ms. Horvat?
Against.
Mr. Hunter? Mr. Krishna? Ms. Leeper?
I abstain.
Mr. Lerner?
I abstain.
Mr. McKenzie?
Against.
Ms. McLean?
Against.
Mr. McDowell?
For.
Ms. McGrath?
For.
Mr. Marmer?
For.
Ms. Matheson?
For.
Mr. Mercer?
For.
Ms. Minor?
For.
Ms. Murchie?
Against.
Mr. Porter?
Against.
Ms. Potter?
For.
Mr. Pustina?
For.
Mr. Rabinovich?
For.
Ms. Richardson?
For.
Ms. Riche?
For.
Mr. Robbins?
For.
Ms. Rothstein?
For.
Mr. Sandler?
For.
Mr. Scarfone?
Against.
Mr. Sheavis?
For.
Mr. Sikand?
For.
Mr. Silverstein?
For.
Ms. Strasburg?
For.
Mr. Strasburg?
Against.
Mr. Sullivan?
Mr. Sullivan's for.
Okay. Ms. Symes? Ms. Symes? Mr. Wadden?
For.
Mr. Wardle?
For.
For, 13 against, 2 abstentions. The motion carries. We're going to now break for lunch, and we'll come back at 2:30. Thank you, everyone.